Shortly here from the legal team of the second respondent, President Akufo-Addo. But the Supreme Court, as you know, did order the former Deputy Attorney General to publicly apologize for some comments that he made against the panel members. Now, the member of the legal team of the petitioner in the ongoing election 2020 petition is reported to have accused the court panel of having a, quote, predetermined agenda to rule against the 2020 NDC presidential candidate John Mahama. Dr. Ayene, who was unhappy after the panel in a unanimous decision dismissed an application after the court dismissed application by Mr. Mahama to reopen the case, said that he was surprised that the panel is trying to expunge 4 of the 5 issues raised by the petitioner. The Boga East MP said one of the 5 key issues being adjudicated makes the EC chairperson a party to the suit. Let's go back to the court right now. Kojo Nkrumah is speaking.
For the several hours of today, the legal arguments that were made by counsel for the petitioner and then responded to by counsel for first respondent, counsel for second respondent. I think at the end of the matter, I want to draw your attention to the words of the Supreme Court speaking through His Lordship the Chief Justice in ruling. And I want to focus on that because lawyers express their opinions on the law, what they think the law means, what they think a proper construction of the law ought to mean. And I think today you are noticing that our friends on the other side now keep using the phrase that in our opinion, in our opinion, in our opinion. Initially, the argument was as though it was fact. But you notice that the positions that they were expressing are not supported by the law or the principles of equity. So even a reiteration of it before the press and a re-explanation does not change the fact that the law does not support the position that they've been expressing. And so we will not go into a reiteration of all the legal arguments that we made. I think this is about the 3rd time that the court has dealt with this type of issue and has come to a certain conclusion on it. The court also says that they did not satisfy even the minimum threshold required to sustain an application of this nature. You know, sometimes when we make this point, it appears as though we ourselves are saying it. We are not the ones saying it. The court, I think this is the 3rd time that the court has made the argument that the law does not support their position. They have not met the legal threshold. So we are not the ones saying that what they are saying does not align with the law. For someone to say we are disrespecting our seniors, etc. The court, the Supreme Court of the Republic of Ghana, is the one that is making the point that they have not satisfied even the minimum threshold. So we won't bore you with too much detail. The court has decided that on the 4th of March, judgment should be delivered in this matter. This is after the petitioner who came to court, among other things, arguing that nobody won this election, has called 3 witnesses, and has now, I think in the last 2 or 3 applications, been praying the court to literally force the EC chair into the box so that he can reopen his case and advance something else which he hasn't told the court, something else that can help make a better case for him. The court has decided that despite its earlier warning that if its processes are not complied with, it can strike out the matter, it will still accommodate them so that they can file their written addresses. I think this is clear evidence that nobody's being denied a fair trial here. The court has bent itself backwards and is accommodating the interest of all parties. So we look forward to the 4th of March for judgment. If it is the view of the court that they want to invite our lawyers, viva voce, to address some issues, they are more than prepared so to do. But Ghanaians have followed the journey that has gone on so far in the courts, where the petitioner was being looked to adduce the evidence. I heard our colleagues here saying that the mathematics is clear, but you have been here covering for all the days that we have been here. And I'm not sure that to you, you saw mathematics that yielded results other than 47% for the petitioner, Mr. John Dramani Mahama, and 51.2% for the second respondent, Nana Addo Dankwa Akufo-Addo. That was the mathematics that you saw Mr. Johnson Asiedu Nketia arrive at. That was the arithmetic that he arrived at, the answer that he arrived at when he did the various computations. Today you are hearing them telling you that the mathematics is clear, nobody crossed the 49%. But in the wells of the Supreme Court, before the justices, I'm not sure you have seen them prove that. But in any case, we'll come back on the 4th, and then we'll stand by for judgment. So we'll keep it simple. We'll take your questions, and when I'm done, my colleague Nana B will do a quick Twi translation, and then Faisal will do a quick Hausa translation for us. We're going to take your questions. So for those who didn't hear the question, his question is the admission by the petitioners team now that they are willing to explore other avenues for the so-called accountability and truth that they talk about. First of all, let us reiterate that the truth is what has been laid before the court. The truth is what has been gazetted. That Nana Addo Dankwa Akufo-Addo, when you add the 38,000 plus polling stations, or you add the 275 constituencies, or you add the 16 regions, the truth is that Nana Addo Dankwa Akufo-Addo crossed with over 500,000 votes as a margin. It is the petitioner who seeks to challenge this truth, but has not brought his truth to court. Whatever counter evidence that he may provide to cause even the chair of the first respondent to get into the box, I'm not sure you have seen it here. But today they are admitting before you that they are willing to explore other avenues of accountability. Remember, about 2 weeks ago, we've been arguing before you that if you want accountability, generally, you can come to Parliament. The parliamentary committees of inquiry that can look into whatever matter you bring, and there's a 137 plus 1 Parliament. You can come to Parliament. You can come under the Right to Information Act, asking for some particular information. If it's judicial review that you want, that you think that the EC has not done something specific and the courts must bring its power to bear on it, the high courts are there for judicial review. So it is interesting that at the end of the case, when we are all wondering where the evidence that they were supposed to provide to back their case is, they are now opening up to you that they are willing to consider other platforms of accountability. We'll see which ones they choose, what case they make, and if there's any adverse arguments that need to be made there, we'll respond accordingly. Are there any other questions? Like I said, we know the big story that you have today, so we won't bother you with too much talk. Nanabi.